10 Britain's forgotten laws that still exist today. The UK is known for its modern laws, but hidden in old legal texts are rules that seem more like jokes than actual legislation. From banning suits of armour in Parliament to outlawing the suspicious handling of salmon, these bizarre laws still technically exist. While rarely enforced, they offer a hilarious look into Britain's quirky legal history. In this video, we'll count down the 10 strangest UK laws still in effect. Some are funny, others are baffling, but all are 100% real and serve as reminders of how peculiar history can be. 10. It's illegal to wear a suit of armour in Parliament. Under the Statute forbidding bearing of armour, 1313, passed during King Edward II's reign, it is still technically illegal to wear a suit of armour in the Houses of Parliament. The law was designed to prevent nobles and knights from intimidating politicians during heated debates. It's never been formally repealed. While it's a historical curiosity today, this statute is often cited in legal trivia and remains one of the oldest unrepealed laws in Britain. It's highly unlikely anyone would test this in modern Westminster, but if they did, the Sergeant-at-Arms might have something to say. While it may sound theatrical today, the law once played a serious role in keeping debates civil. 9. Handling salmon in suspicious circumstances is a crime. Section 32 of the Salmon Act 1986 makes it an offence in England and Wales to handle salmon in suspicious circumstances. The law was aimed at tackling illegal salmon fishing and black market sales. The phrase is intentionally broad to cover various forms of illicit activity, such as poaching and unlicensed dealing. Though often mocked for its odd phrasing, the law is real and occasionally cited in fisheries enforcement. It's an example of how serious conservation goals can lead to some of the strangest sounding legal language. Over time, this oddly worded law has gained a kind of cult following. It's cited in law school textbooks, legal comedy sketches, and trivia nights. 8. It's against the law to be drunk in a pub. Under Section 12 of the Licensing Act 1872, it is illegal to be drunk on licensed premises. This includes pubs, clubs, and bars. Landlords can also be fined if they allow someone to become excessively intoxicated on their premises. This Victorian law aimed to combat social disorder caused by drunkenness. While it's rarely enforced to the letter today, police can and do use modern public order laws for similar offences. It remains an ironic law in a nation where pub culture is practically sacred. In modern times, the law has come up occasionally during disturbances or when police are dealing with habitual offenders. It empowers authorities to intervene before a situation escalates. For pub owners, it also sets clear boundaries, serve responsibly, or face legal trouble. While the law may sound outdated, it plays a subtle but important role in managing nightlife behaviour and alcohol-related harm, especially in town centres. 7. You mustn't shake a rug in the street after 8 a.m. The Town Police Clauses Act 1847 makes it unlawful to beat or shake any carpet, rug or mat in the street after 8 a.m, except for doormats, which can be shaken before that time. This law reflects Victorian efforts to improve public hygiene in increasingly crowded cities. Dust clouds from carpets could affect nearby shops and homes. Though dated, the law still exists in many local government bylaws across the UK. The regulation was part of a broader trend in 19th century Britain to bring order and civility to public spaces. Alongside rug shaking, laws also govern chimney sweeping, street music, and waste disposal. This law's precision, specifying an 8 a.m. cut-off, reflects the Victorian obsession with orderliness and punctuality. It's oddly charming and a little controlling, but a snapshot of the era's urban reform movement. 6. It's illegal to carry planks of wood along pavements. According to Section 54 of the Metropolitan Police Act 1839, It is illegal to carry planks, ladders, or poles along public pavements in a way that could obstruct or injure pedestrians. This regulation was meant to protect city dwellers in dense urban environments. It also applies to items like pipes, bars, and boards. Though it's highly unlikely to be enforced today, it's still technically valid law within the City of London and some other jurisdictions. The regulation wasn't just about inconvenience, it also addressed legitimate safety issues. Tripping hazards, limited visibility on narrow streets, and collisions between passers-by were common in the early 1800s. Today, these issues are handled through broader health and safety legislation, but the original law remains. In fact, similar restrictions apply in some modern city ordinances across the globe. It's a reminder of how urban living has always required careful negotiation of shared space. 5. No knocking on doors and running away. The Town Police Clauses Act 1847, Section 28, prohibits willfully disturbing occupants by knocking on doors or ringing bells without lawful excuse. This directly targets prank-style behaviours like knock down ginger. Although this law is rarely applied today, it exists to address harassment, not playful mischief. However, repeated disturbances could legally escalate into antisocial behaviour cases under modern local authority powers. While it may sound like a minor annoyance, this law has roots in protecting vulnerable residents, especially the elderly, from repeated disturbances. In today's context, the spirit of the law is echoed in modern antisocial behaviour orders, ASPOs, and local council interventions. Some localities still cite this provision during Halloween or prank-heavy seasons. Though outdated in its wording, the intention to safeguard public peace remains relevant in densely populated neighbourhoods. 4. It's illegal to be drunk in charge of a cow. Under Section 12 of the Licensing Act 1872, it is not only illegal to be drunk in a pub, but also in charge of any carriage, horse, cattle, or steam engine. Being intoxicated while responsible for animals was considered a public hazard. While the image of someone drunkenly walking a cow is comical, this law was taken seriously in rural Victorian communities. It technically still applies, though enforcement would be unlikely in today's world unless safety was clearly at risk. Interestingly, this law isn't just about livestock. In some rare cases, people have been fined or cautioned under this act for being intoxicated while cycling or operating farm equipment. It shows how legal definitions of vehicle or charge. 3. You can't use your phone to pay at a drive-through. Under Regulation 110 of the Road Vehicles, Construction and Use. Regulations 1986, amended in 2003 and clarified in 2019, it is illegal to use a handheld mobile phone while driving, even if the engine is running and the car is stationary in a drive-through queue. Unless the engine is off or the phone is mounted and hands-free, even tapping to pay can technically constitute a traffic offence. Though enforcement is rare in these scenarios, the law is real and has resulted in fines in some cases. This rule highlights the legal challenges of modern-day living. With the rise of mobile wallets, smartwatches, and even facial recognition payments, it's clear that regulations haven't kept up with technology. What counts as using a phone? Does holding it? 2. It's illegal to import Polish potatoes. The Polish potatoes, notification, England. Order 2004 prohibits the import of potatoes from Poland without notifying UK authorities and obtaining proper documentation. This law was introduced because of repeated outbreaks of ring rot in Poland, a bacterial disease that devastates potato crops and is difficult to eliminate from soil. The UK's agricultural industry, especially in regions like Lincolnshire and Cambridgeshire, took this threat seriously. Even though the UK has since left the European Union, this quirky-sounding law remains in force. It's a reminder of how specific and targeted agricultural laws can be when crop security is at stake. The law also illustrates how biosecurity issues can impact international trade, even in unexpected and oddly specific ways. 1. You can't slide on snow in public places. According to the Metropolitan Police Act 1839, Section 54, sliding on ice or snow in public streets is still considered an offence. This law was created in an age when winter injuries were more serious due to limited medical care. Ice slides and spontaneous snow games could result in accidents that overwhelmed local infirmaries. In the early 1800s, cities were crowded, sanitation was poor, and safety regulations were minimal. Lawmakers decided to crack down on playful but dangerous behaviours, including something as innocent as sliding on snow. Today, the law is mostly forgotten, and people sled freely in parks across the UK. Still, its existence shows how Victorian lawmakers tried to legislate even the smallest risks to public order and safety. It also reflects the British tendency to use very formal laws to govern informal, everyday activities. From medieval armour bans to obscure salmon handling laws, Britain's legal archive is filled with forgotten rules that reveal the quirks of its past. These strange UK laws may not affect your daily life, but they offer a hilarious and fascinating glimpse into the nation's evolving standards, values, and sense of humour. Thank you for watching this video. Please don't forget to subscribe and turn on the notification bell.